Good morning, good afternoon. On behalf of the Center for Constitutional Studies and Leiden Law School, we want to greet you. We want to welcome you to the opening session on this webinar series. It's about access to justice for children in the face of the convention, the United Nations Convention on the Rights of the Child. It's a pleasure to have you here. In a bit, I will share with you the structure of this cycle, and I will also introduce you to our panelists. But before we do that, I leave you with the director of the Center of Constitutional Studies of the Supreme Court of Justice of Mexico, Dr. Ana Maria Ibarra, who will salute you on behalf of the Supreme Court of the nation. Thank you very much, Nicolás, for this introduction. We're extremely happy at the Mexican Supreme Court to encourage this initiative, this series of online seminars on access to justice for children. And we're thankful to the University of Leiden Law School for this collaboration. It is wonderful to have the opportunity to hold these exchanges and discussions with experts from all over the world. This is very important for us to be able to undertake a comparative law. The University of Leiden Law School and the Constitutional Studies Center underscore their devotion on the right of the child. We have a research line on this topic, and we are highly interested in bringing Mexican jurisprudence closer to all the justice system users through our training courses, through which we try to organize ourselves regarding several rights. And we're working on a handbook on childhood and other rights, like the right to scientific evidence, the right to reparation. And that's also the reason why we need to come closer to comparative law, to sentences from other jurisdictions, and to what the University of Leiden is doing with the observatory on the rights of children, that are providing us with critical access to review progress made in the jurisprudence. And I'm also very happy, and the court wants to thank you all, because the next days we will present the Spanish version of this observatory. It is paramount to bring our work to scholars, to users of the justice system, to review the jurisprudence. That's the point, to set it forth for everybody. And as I mentioned, this conference cycle, throughout the conference cycle, you will listen scholars from Latin America, from Africa, from Asia, from Europe. And that is the challenge, to start out the conversation, to consolidate a type of justice that is friendly with children. Thank you very much, Ton Leafford. Thank you, Nicolás Espejo, for encouraging the collaboration between the University of Leiden and the Constitutional Studies Center. It is very important to have this opportunity. And on behalf of the Minister President Arturo Zaldívar of the Supreme Court of the nation, thank you for this effort. Throughout many months, we will keep on with these conferences, reflecting and exchanging ideas. And we want to thank our two speakers. Ton will be one of the speakers, and Mikiko Otani, thank you very much for accepting our invitation to join us in this table. Thank you very much, Nicolás. Thank you very much, Ana Maria. We want to thank you for supporting these activities. Before we move on with the formal presentations, I leave you with Professor Ton Leafford from the University of Leiden Law School, so he can start with his opening remarks.
Thank you very much, Nicolás. Thank you very much, Ana Maria Ibarra, for your opening statement. Good day to you all. Thank you for participating in this first webinar series focused on the access to justice for children, and more specifically also on the meaning of the optional protocol to the CRC, the Convention on the Rights of the Child, on the communications procedure. It is my pleasure as the Vice Dean of Leiden Law School to welcome you all on behalf of Leiden Law School. Leiden Law School is the law faculty within the Leiden University, based in the Netherlands. Leiden University is the oldest university in the Netherlands, established in 1575, and the Faculty of Law, nowadays Leiden Law School, has been part of that ever since. Over the past decade, Leiden Law School has developed itself into a center of expertise around child law and children's rights. And from that perspective, we are very grateful for the new partnership between the Center for Constitutional Studies of the Mexican Supreme Court and our law school. And this partnership is meaningful in many different ways, but specifically because we bring together our forces and interests in the promotion of children's access to justice. And through this collaboration, we will be able to provide a comparative perspective on access to justice for children in its various forms, and not only connecting our regions, Europe on the one hand, and Latin America and Central America on the other, but also we also like to see this partnership develop into a partnership for many more people also from other parts of the world. So we are very grateful to the Center for Constitutional Studies as well as the Supreme Court for reaching out to us to start to develop this new partnership. And indeed, as was mentioned before, this webinar series, which starts today officially, is one of the outcomes of this partnership, as well as the Spanish translation of the Leiden Children's Rights Observatory that will see the light in the weeks to come. And we are very, very grateful for the support from the Supreme Court and the Center for Constitutional Studies. And through that, we will be able to expose many more people to the observatory. So on behalf of the Faculty Board of Leiden Law School, I welcome you. I wish you a very inspiring afternoon or morning or evening, depending on where you are. And we look forward to seeing you not only today, but hopefully throughout this series. And I'm sure that Nicolás can tell you much more about the series as such. Thank you again, and I look forward to a fruitful conversation.
Thank you very much, Ton, for your kind words and for the support of the Leiden University School of Law. What I would like to do now, before I give the floor to our speakers, is to share with you the structure and the main topics of this cycle of online seminars. As Ton described, this is a cycle on access to justice with specific attention on the innovative mechanism, which is the system of claims protocol before the Committee on the Rights of the Child. And we will take a look at more general affairs related to access to justice. We will not only talk about procedures, we will not only talk about jurisprudence performed by the committee throughout the years and the challenges therein, in the dogma and in the practice, but we will also try to understand what does it mean in practice to have a friendly access to justice for children. This is why throughout the cycle, you will see that the panelists invited, who have kindly offered themselves to join us, are people that share that dual vision. That is to say, these are people who have an academic interest on one hand. They're more interested in teaching and doing research on justice for children. But many of these speakers also come from the practical landscape. They have a significant expertise as attorneys, as litigators. They've been the defendants. Then they work directly with children in strategic litigation. They think about the processes throughout the world. They conduct monitoring, and their perspective, as Tan said, is not only the Netherlands or the Mexican perspective, but this will be more of a global perspective that truly represents the different regions that are building. And we hope that alongside with the children, a friendlier, both local and global type of access. This is what we wanted to aim for. We will review affairs related to admissibility. There will be a specific session devoted to the challenges of admissibility that the committee has to dealt with throughout recent years. There have been interesting cases where the committee in certain cases had to decide to resolve admissibility, and the messages conveyed by the committee in spite of not moving forward with the depth of the cases. This is interesting to analyze how it intertwines with the rest of the global committees that also have individual reporting mechanisms. We thought that this was interesting as well. And we will more specifically see the jurisprudence of the committee. We will have a specific session focused on a line of cases that is very important for the committee, the protection of the rights of children in the context of international mobility, refugees, asylum seekers, or migrants with massive access to the procedure before the Committee of the Rights of the Child. This is why we believe it is interesting to pay attention to the specific jurisprudence line designed by the committee due to the types of cases. And we will have also a specific view on how children can become active agents in the allocation of both internal and international resources for rights protection. To think of the right, the access to justice of children, but alongside or with the children. So consequently, we invited certain panelists that will provide us with that perspective. They're working on how to promote agency and active participation of children throughout the mechanism, so we do not repeat the active role of children in litigation strategies and the defense of their rights. So we want this to become part of the conversation cycle. And we will also have specific sessions to review how resources are spent, the resources available to protect the rights of the children, and how these resources in the reporting system has been able or will continue to generate more structural changes for the justice of children. We will have a specific session on this idea if the reporting mechanisms are or not, but we want to have that discussion if these mechanisms allow for more structured involvement beyond the importance of the specific case. And we will have a specific session where we will discuss this matter, reporting as a structural transformation mechanism for the rights of children. And we didn't want to waste the opportunity to open up a specific session on Latin America. We thought that it was significantly important to open up a space of discussion on how to strengthen the facultative protocol and access to friendly justice throughout the region. And the last session will be devoted to discussions about Latin America, the protocol and empowerment strategies for children so they can have access to friendly type of justice, which is a major challenge. We are hosting in Mexico. However, Mexico has not yet ratified the third protocol to the convention, and not even the Netherlands, which is the other country represented herein by the University of Leiden. We do not believe that this is a paradox, but we believe that this is this is a precious challenge that we're undertaking as a law school, Leiden University and Center of Constitutional Studies, so we can explain how the integrated systems can become strengthened. So we do hope that this cycle triggers the soon ratification and implementation of the protocols by both Mexico and the Netherlands, and we do believe to make contributions to that regard. Without further ado, I apologize for the delay, but we did want to share with you our thoughts for the series where we will have several speakers from all over the world. And now allow me to introduce you to these dear panelists, friends, and colleagues who are joining us here today. Let me introduce you first to Mikiko Otani and afterwards Tom Leafford, although in the presentation we will start out with Tom for a more general presentation about the right to access justice, and after that we will continue with Mikiko. But it is my pleasure to present Ms. Mikiko Otani. Mikiko is a member of the Committee of the Rights of the Child since 2017 in representation of Japan. She is a citizen of Japan, and she is the chair of the Committee of the Rights of the Child of the United Nations since 2021. As a matter of fact, she is the first attorney from Japan who has chaired the Committee on the Rights of the Child. She is a family lawyer, broadly respected internally and internationally. She had worked in conciliation as well for the Tokyo Family Court since 2003. She is also a member of the Board of Attorneys of Tokyo in the Family Law section. And she's also a member of the Japanese Association of Social Legal Studies and Family Law. She has developed, let me correct myself. She has broad academic experience from the University of Tokyo, Columbia University, and the University of Tokyo, and broad experience with NGOs and working in the promotion of human rights, both internally and internationally. Her main working focus has included the rights of children and migrant women, human trafficking, international kidnapping of children, the development of resources to protect ourselves from human rights violations, and access to justice for groups whose human rights have been violated. And as a scholar and researcher, she worked at the University of Osaka, and she has also been part of training lawyers in Cambodia, Mongolia, Iraq, Iran, Malaysia, among others. It is a great pleasure to have her here today with us. So I want to thank Mikiko for joining us. And immediately, let me introduce you to my dear colleague and friend, Tom Leafford. He is Vice Dean of Education of the Law School at Leiden University. He is Professor of the Rights of the Child, and he holds the UNICEF faculty and member at University of Leiden. He holds a master's degree in advanced studies on the rights of child by the University of Leiden, which is the only LLM program on the rights of the child in Europe, a founder and member of the Academic Council of the Children's Rights Observatory of the University of Leiden, and coordinator of the summer school that develops in Leiden in European summers and also other courses. He is a coordinator, and along with the Center of Legal Studies, Grocio, he is the coordinator of the annual contest on the rights of the child held in Holland and the Netherlands, with the participation of different law students from all over the world. He is also a member of the Court of The Hague, and he was juvenile honorary judge at the Amsterdam Court from 2010 to 2017. He has written several publications. I will not give you the details now, but they cover different areas: deprivation of freedom among children, access to friendly justice without any doubt, leads us to understand. I'll leave you with Tom Leafford from the Leiden University Law School for his presentation. We will have 20 minutes by the end, 10 to 15 minutes, and after that we will open up to questions.
Thank you so much, Nicolás, for these kind introductions, and welcome, especially also Mikiko Otani. It's an absolute pleasure to be with you in the same panel, and also an honor for me to present next to you. Today's seminar is paving the way for the others, so to say. So it is an introduction to the other webinars, and my plan is to discuss how access to justice for children emerged over the past 10-15 years as a concept relevant for children's rights protection. And I would like to explore a few avenues with you on how to give this concept practical meaning. And I would like to discuss also what, in my view, the potential of the third optional protocol to the CRC is in that regard. But I will do that briefly in order also to give Mikiko Otani the room to give her reflections as well. It is, I think, very important to acknowledge that access to justice for children should be seen in light of the fact that children's rights are human rights, and children's rights have become part of our narrative as far as children's positions are concerned in law since the adoption of the Convention on the Rights of the Child, of course, as you all know, a document that can count on support from 196 jurisdictions in the world. But it's important to make that point up front, that children's rights are human rights, because of that, they are part of international human rights law, and access to justice is a very important vehicle to protect the human rights of individuals. And in a similar way, it is a very important vehicle for children to protect their human rights, or more specifically, their children's rights. International human rights have impact in legal systems across the globe in many different ways, and they play a role in many different legal domains. So we are talking about family law, child protection law, juvenile justice, criminal justice, immigration law, but also other fields of law in which children's rights matters are addressed. Think of tort law, think of consumer law, consumer protection, administrative law, and also education and health law. So human rights play a role there, and children's rights as part of that. Because of the fact that children's rights are part of international human rights law, they are also to be seen in conjunction with other fields of international law. And for children and families in particular, of course, private international law, but also international criminal law and international humanitarian law, and international labor law, of course. And access to justice is to be seen in light of not only the interaction between international children's rights and other fields of international law, but also with regard to the implications of international human rights law for domestic legal systems in a wide variety of ways. Access to justice often revolves around the question to what extent of how should we look at the accountability of the primary duty bearers for human rights protection. And it's also for that reason that it's very important to acknowledge that children's rights are part of the human rights framework, because it comes with accountability, it comes with commitment, and ratification doesn't come without commitment. It comes with negative as well as positive obligations, assuming accountability for children's well-being on the short and long term, and as part of that, for the protection of rights of children who are to be seen, and Nicolás mentioned that already, as actors, as agents in their lives. It was once mentioned that because of the recognition of children's rights, children are to be seen as agents in their lives, and children's rights give children a way to hold duty bearers to account. So what did we see over the past 32 years? We've seen a lot of activity around children's rights implementation, and I'm sure you all have been part of that, or you know about it. And we've seen tremendous efforts across the globe to domesticate the Convention on the Rights of the Child in the domestic legal systems through law and policy reform, through awareness raising and training of professionals, sometimes even raising professional standards. We've also seen an increasing amount of monitoring activities, not only taking place by the Committee on the Rights of the Child, but also at the domestic level, for example, by national human rights institutions and children's ombudspersons. We've also seen that children's rights have started to influence regional systems, and some regions have even developed their own agendas around children's rights and developed strategies around children's rights implementation, relying not only on the UN Convention, but also on regional instruments that are closer and more nearby, but can also better connect to the diversity of realities in which children grow up and live. We've also seen that children's rights are not only relevant for actors, of state actors, I should say, as the primary duty bearers, but we have also moved beyond that. And we are also now much more than before talking about the responsibilities of non-state actors for children's rights protection. And access to justice has to be seen in light of that development as well. And moreover, of course, we've seen additional standard setting internationally around the International Development Agenda, which was also informed by international children's rights. And of course, we've also seen the entry into force, the adoption and the entry into force of the optional protocol on the communication procedure, providing children with the right to lodge individual communications at the international level before the Committee on the Rights of the Child. Yet, despite all these implementation efforts, we also see that there is a significant justice gap. We are still struggling across the globe with the recognition of children as rights holders. We tend to be very arbitrary there. We don't always see children as completely equivalent to the human rights protection. So one may wonder, for example, to what extent children have the right to have their dignity protected in the same way as adults. We are struggling, and this is euphemistically used, of course, the wording struggle, but we are also really having an issue with securing equal treatment and inclusive treatment, for example, at the cost of girls or children belonging to certain minorities. And these children are in law and also in practice not always seen as the same children having rights, and in a relation to that also having the right to access justice. We are also seeing that we are not living up to all the obligations under international human rights law as far as the visibility of children is concerned in our decision making, even though children have a strong set of participation rights. Our approaches towards children are often far from being child-centered, or really and truly child-centered. And that all ultimately boils down often also to a lack of accountability. Accountability meaning that states do not live up to their commitments, and also meaning that children ultimately enter into some kind of legal void as a consequence of which they cannot benefit from the rights they are entitled to. More specifically, we see a lot of confusion and misunderstanding of roles and responsibilities between state and non-state actors, between central government and lower government, but we also see that many nation states hide themselves behind their borders, and they take a rather traditional approach towards issues such as jurisdiction and responsibilities for non-nationals, as a consequence of which we see that children struggle and are not seen as and approached and protected as rights holders. Moreover, I think we have an issue around emerging areas in which we still have a lot of exploration to do, standing in the way of acknowledging accountability, but also understanding the implications of accountability. And emerging areas that could be mentioned here are issues related to the digital environment in which children live and grow up and engage with each other and with others. But also we could also think of the environment and climate change areas, and also, for example, biomedical issues and children's rights is something to be further explored. When we talk about access to justice, we are talking essentially about accountability and securing accountability through access to justice systems in its many different forms. And the Committee on the Rights of the Child quite quickly acknowledged that and also carried out the message that if we want to give rights meaning, we have to make sure that there are effective remedies in place that are available also to redress violations. Also in academic literature, statements were made around the importance of having remedies, or as Michael Freeman puts it, otherwise, rights are purely of symbolic importance and not really more than that. In 2013, the United Nations High Commissioner for Human Rights made very clear that access to justice is to be considered also with regard to children. And if we talk about access to justice for children, we mean the ability to obtain a just and timely remedy for violations of rights as put forward in international and national norms. And that particular statement also informed the Human Rights Council, which in 2014 adopted a special resolution on access to justice for children. Certainly, the emergence and ultimately the entry into force of the third optional protocol also confirmed that children have a right to access to justice, which is not only about accessing justice systems, but also accessing effective remedies, remedies that really secure adequate child rights protection. Access to justice is more than seeking remedies. It is part of the rule of law. It's part nowadays also of the Sustainable Development Agenda, referring to the importance of the promotion of peaceful and inclusive societies, providing access to justice for all. Access to justice is connected to the very heart of the rights of the child. It's going straight into the recognition of children's rights to have rights, the recognition of children as rights holders. It's meant to recognize that children have human rights. It's meant to shield children from violations of rights. It's meant to provide remedies that are child rights based, to secure protection of rights, to prevent violations, in other words, also of other children, not only of the children who complain, for example, but it's ultimately also meant to promote systemic change. And I'll come back to that in a minute. Revolving around accountability of not only states, but also non-state actors, and also acknowledging that children have individual interests in securing rights protection, but children as a group in the same way. Yet, children suffer from very specific challenges that we need to acknowledge when we talk about access to justice. Often, and I'm now zooming in on domestic level, when we talk about access to justice, we see that children struggle to access justice because of legal barriers. Many systems across the globe do not acknowledge that children have an independent right to access justice, independently from their legal representatives, parents, legal guardians, and others. They often are also denied legal standing in the way of accessing courts when their interests are at stake. At the international level, often legal capacity is acknowledged or legal standing, but in practice, children also struggle to find these avenues. And we see also from research that often children are not the ones who are lodging complaints or communications or conducting lawsuits. It's often others who do that for children or on behalf of children. Secondly, we see that children struggle more than adults from socioeconomic situations and conditions standing in the way of them accessing justice, for example, because of the lack of legal aid and legal assistance. The dependency here is a particular problem for children, but it also means that these lack of resources are standing in the way of their independent right to access justice. We also see that children are excluded from having access to justice, starting with no access to information or no legal or other appropriate assistance. And in some contexts, that seems to be more problematic than others. For example, in the context of immigration, we see that there's more reason to be concerned about these kind of exclusions and discriminations compared to other systems. Specific groups of children that are struggling in this regard are girls, for example, but also children with disabilities. We also see reports showing that there is still the persistent existence of what you could call traditional attitudes towards children and children's rights, standing in the way of acknowledging that children also have the right to access justice. And that starts by a lack of recognition that children have rights and therefore can also be victims of violations of rights. But sometimes we are talking about a de facto lack of a child rights focus, meaning that cases are approached from a different perspective than from a child rights perspective. And Claire Fenton-Glynn, in her recent book on children and the European Court of Human Rights, point at this problem also in relation to the case law coming out of the European Court of Human Rights. And she is very concerned about the adult-focused prism that we see often in this case law. And it's often about the rights of adults, for example, versus the interests of children, which makes her wonder whether children have rights or at least are seen as rights holders in the first place. And finally, we are struggling with acknowledging that children cannot automatically assume to have the capacity to participate. There's no reason to deny rights for that matter, but it's really an incentive to invest in empowerment of children and legal empowerment of children, but also in making systems more child-friendly, child-adjusted, or child-sensitive. And I would like to focus on 2 points in relation to this final point, the lack of empowerment and the lack of child sensitivity. And the first question I would like to raise is, how can we actually make sure that justice systems are more accommodating to children? How can we make sure that justice systems are more accessible to children? And I think we could benefit from the concept of child-friendly justice here. It's not a perfect world, but it's nevertheless a concept that is really based on the international children's rights and children's rights developments. And it really addresses the position of children before, during, and after justice proceedings. And if you have to break it all down to its very core, then we are talking about different components that should be taken care of. One is that we should prevent that children are forced into justice systems, because generally children's justice systems are not made for children. Of course, you want to prevent violations of child rights in the first place. But in addition to that, we have to make sure that systems are accessible, accommodating, that they are responsive, that professionals involved in the system are responsive, that children are adequately equipped and also supported with information and specialized assistance, but also that we need to talk about accountability, not only in relation in the general terms, as I referred to earlier, but also within the system. What, for example, does an authority do, a judicial authority do in reporting back to children to what extent the input of children themselves has played a role in the decision-making and ultimately in the outcome of the case. And we also have to make sure, and that is really connected to this concept of child-friendly justice, is that remedies have to be in place, but also to secure outcomes for children that are outcomes that children also expect. And that brings me to the second question I would like to address here. of course, in brief terms, and I hope that some of these elements will be fleshed out further in the webinars to follow, is how can we make sure that remedies and outcomes are indeed child sensitive and also meeting with the child's expectations. And there we have to be clear, we need much more further thinking around this. But we see some interesting things happening. We see, first of all, an acknowledgement that outcomes for children are to be seen in terms of just and fair outcomes, but also equitable outcomes. So again, it's not only about granting access to a system that is responsive and accommodating and empowering. It's also, it should also be about systems in place to secure that children really benefit from lodging a complaint, for example, and really benefit from the outcomes. The Committee on the Rights of the Child in this regard points at Article 39 of the Convention, which is essentially about what we owe to victims. And you could read there, victims of rights violations. And what we see so far, what has happened under the optional protocol to the CRC, we see that the committee is very active in making this work, and also in making sure that the outcomes of the proceedings before its committee are indeed resulting in concrete and tangible outcomes for children, either on the individual level or more in general terms through instructions towards states parties to secure that there is a movement towards systemic change. Examples include specific rectifications of birth certificates, taking interim measures, offering compensation to children. In addition to this, we also see that the committee instructs states parties to provide for more general remedies, focused, for example, on providing free legal aid, making sure that professionals are adequately trained, making sure that counseling is provided to children in individual cases, but also in general cases. And in doing so, I think the committee has started to make the outcomes child rights oriented, child rights based, but also connected to what we can assume that children expect. But do we really know what children actually expect? And I think there is still a serious gap in our knowledge here. First, do we ask? Second, are we secure enough in answering the question who in fact accesses justice? Do we report back to children? A very interesting development here is the committee's open letter, which was published after the climate change case for the first time, as far as I know. And do we have anything happening as a follow-up after justice has been done? I think these and probably some other questions are there to be asked. And that's really something I think we should do together. And I hope that throughout this webinar series, these questions will be addressed as well. So access to justice, and I wrap up, is a concept that emerged. It's not new, but for children, it's more recent. But it is still a concept in need of further development and thinking, and also practical enforcement. It needs a child rights focus, not only in terms of accommodating children well, but also in terms of securing outcomes that connect to children's rights and children's expectations. And I think there is a big role for the committee to play, primarily not only because they are the implementation body of the convention, but also because they have this new vehicle that allows them to make work of this. With that, I would like to close and hand over to my colleague Mikiko. Thank you very much.
Thank you. Very pedagogical, but in turn quite challenging with regards to the pillars that imply, the barriers on the one hand side, but challenges on the other, so as to consolidate children's justice at the different levels. And now I wish now to introduce Mikiko Otani. She's president of the Committee of the Children's Rights. I introduced her before, and she shall be sharing the next 25 minutes with us. And she shall be giving her practical vision as a lawyer, litigation lawyer, and an activist concerning access to justice in practice for girls and boys. Thank you, Mikiko, for being here with us today.
Thank you, Nicolás, and thank you, Tom. This topic, access to justice, is very close to my heart, and I decided to share some of my thoughts around this topic, not so much as a chair of the Committee on the Rights of the Child, but as a practicing lawyer who has been working for access to justice, and not only for the children, but for all those who do not have access to justice. Because I can speak on this about this topic for hours, so please stop me if I am going to run over 25 minutes. When I was a university student, I studied law at the college, the university, undergraduate, and also the graduate. But I learned about the human rights for the first time in the Japanese constitution. So later on, of course, I was introduced to international human rights law, but that was only after I became a lawyer. I started practicing law. When I learned about the human rights in the constitutions, I was very impressed, and I was very much interested in the human rights. But at that time, I didn't know how actually the human rights provided in the constitutions will be realized. What I learned from the constitution law course was the professor said that courts or judges realize the human rights. That's what I learned in my constitution course. I became a lawyer. I started practicing law in 1990. Immediately after I started practicing, I started wondering actually how human rights are realized, because now I'm a lawyer. And so according to the national law, like civil law in Civil Code of Japan and civil procedure law, the persons can go to the court without a lawyer. However, when the persons feel that their rights human rights were violated, it's so difficult, it's not so realistic for them to file a case with the court without the lawyers. So actually, though the professor said that courts and judges are the mechanism and the persons who realize the human rights, I realized that actually the lawyers are forefront as a first point for the victims of the human rights violations to access to remedies or the justice. But in 1990, the number of the practicing lawyers in Japan was so small, and the advertisement of the practicing lawyer was prohibited. And very often the people don't know where the lawyers are and how to get the access to the lawyers even. The judicial proceedings takes long, many years. Sometimes if we go to the Supreme Court level, it takes more than 10 years, sometimes 15 years. In the process, it takes not only the time, but also the costs. And at that time, there was no national legal aid system available for the people who need the legal assistance. So, and in addition to that, I realized, even as a lawyer myself, the lawyers are not necessarily being trained in the human rights. Of course, we learned about the human rights as a constitutional law, but it doesn't mean that we were trained in the human rights or the sensitized in the human rights. And I found that it is also true to all the legal professionals, including lawyers, judges, and prosecutors. So very often, actually, the human rights violation victims felt more victimized going through the lengthy process, and they felt that lawyers and judges are not sensitive enough to understand their situations. So I wondered as a lawyer, are we really realizing the human rights, and why the victims have to go through this process only after their rights were violated? And even if they are successful in winning the case after 10 years or 15 years at the Supreme Court level, it's too much. It's so slow. And also the remedies would only help those individual victims. But does that mean that all the victims of the human rights violation have to go through this process individually? So those questions prompted me to think about more about the preventions and how to realize the human rights. And I started being more interested in prevention, human rights educations. And so that was my experience as a young lawyer. When I became interested in the human rights education, I learned about the United Nations activities in the area of human rights. Then I learned about the Convention on the Rights of the Child and reporting procedures and Article 4, which talks about the general measures, what the state parties have to do. So before going to the court, actually the state parties have to take legislative, administrative, and all other appropriate measures to implement the human rights, children's rights. So I was so fascinated by learning this international human rights law, which says, unlike the Constitution of Japan, it clearly says that the state parties have to do this and that. So I learned that a realization of human rights not rest on the courts. Of course, courts would be the last resort for the remedies, but before that, the human rights should be realized through legislation and administrative measures. In 2009, I attended at the side event of the United Nations Commission on the Status of Women on trafficking, because I have been involved in the trafficking issues. There, I met a New York lawyer who was member of the New York City Bar Association Trafficking Task Force team. She spoke that because the victims of the trafficking very often come to the United States for money. They come from the poverty situation, and so they were cheated, but they worked. So the lawyers should help them to get at least minimum wage, she said, and also the compensation. And I was very struck because at that time, the Bar Association, Japanese Bar Association, was advocating for the enactment or adoption of a comprehensive law for the victims of trafficking based on the international the standard. But it hasn't happened many years. And I thought, so this is now other way around. So I started from thinking about the remedies things, and then got interested in the international human rights law. But now again, I thought, I am a practicing lawyer. So though the legislation, administrative measures are so important, but as a lawyer licensed to practice in Japan, so why don't we do more to use my professional qualification to provide the remedies to the victims of the trafficking? At that time, the lawyers around me were thinking that it's very difficult to provide the remedies to the victims of the trafficking, because very often the victims who are identified as the victims of trafficking in Japan go back to the country of origin. So the victims themselves and lawyers and NGOs who are helping the trafficked victims thought that it's not possible. But I said, yes, it's possible, because my area of practice has been international family law, which means that I very often have the clients in other countries who need to file a case in the Japanese court. So handling the case and providing the legal assistance to the persons, clients who are in other countries, it's a part of my practice. So I thought we should do it, the same things for the victims of trafficking. So I started talking to the lawyers around me and started providing the legal assistance to the victims of the trafficking. So this is just my background. When I became to the committee as a committee member, before that, I have been engaging with the committee as an NGOs, but now I am in the committee and I looked at the convention more closely and of course the optional protocol, third optional protocol. What struck me was because I have been also engaging with the other human rights treaties bodies, such as the Human Rights Committee. So I have been familiar with the other international human rights treaties. What struck me is that unlike the International Covenant on Civil and Political Rights, which has the particular article which provides the right to effective remedies, there is no such article in the Convention on the Rights of the Child. Of course, there is some articles such as Article 39, which talks about the recovery and reintegrations of the victims of child victims of the violence. But it's not the comprehensive in my view, and it doesn't have the word effective remedies. Why is that? And even though the Article 39 applies to the victim of the torture, it doesn't say compensation. The Convention Against the Torture has the particular article which provides the right to effective remedies, including compensation. Why children don't have the right to effective remedies? The children are not supposed to receive compensation, even for the serious violation, such as the torture. So I started wondering, and I thought that it sounds like the children are not real rights holders. Because for me, if we say the person has human rights, unfortunately, we have seen the violation of the human rights every day. Having the international human rights law doesn't stop the human rights violation, unfortunately. So when the rights are violated, the justice has to be given to the victims. This is the only way to make the human rights complete. So Tong shared with us the effective remedies is part of the rights. So if we say that children are the rights holders, children have the right to remedies and justice, because the violation of the children's rights are injustice. So the victims need to have the recovery of the dignity, and the injustice have to be rectified. So this is somehow lacking, and Committee on the Rights of the Child needs to do much more about access to justice. So now I come to the optional protocol, third optional protocol. I agree that the third optional protocol is very significant step forward for the children's access to justice. My former chair, Yang Hee Lee, worked very hard appealing to the General Assembly, saying that all other United Nations core international human rights treaties have the procedure, which is called individual communications, but only the Convention on the Rights of the Child doesn't have it. So it was a very strong call, And now the optional protocol, OPIC, gives the international level of remedy procedure for the children. But what does actually mean? When the children file a case and succeed in finding, succeeding in getting the finding by the committee, the violation, does that actually give the children the remedies? The committee can find violations and make a recommendation to the state parties to give remedies. But how actually those child victims will get remedies? The child victims have to go back to the national level again. So I understand that in the session later on, there is some session devoted to the domestic remedies, exhaustion of domestic remedies. So those children, child victims, now, yes, of course, with the third option protocol, so they have the access to justice at international level under the OPIC. But those children, first of all, their rights are violated, which we want to avoid, but unfortunately it happens. So those children have to go through the national remedies mechanism first, and only when it fails, they can come to the committee. And even if the committee finds a violation and make a recommendation to the state parties to give the remedies, children again have to go back to the national level because the implementation of the remedies or recommendations have to happen at the national level. So that mechanism made me think more and more what the committee should do. Firstly, because the fact that the committee accepts the case as admissible, meaning that national remedy mechanisms failed to provide effective remedies to the children. So when the committee finds a violation and make a recommendation about the remedies, in my view, the committee should do, of course, make recommendation to the state parties to provide the remedies to these individual child victims, but also more about general remedies, which will lead structural change. I would say this for several reasons. Firstly, the committee is not the court, actually. The committee is the monitoring body, which makes sure the implementation by the state parties of the convention. So our function, the individual communications, is, in my view, it's part of the monitoring mechanisms. So when, of course, the providing the remedies is very important to this particular individual victim child, but also because we are monitoring body, when we find the violation by the state parties of the particular article, substantive article, for example, right to life or right to health, of course, if this is because of the structural problem, the committee should point out and make a recommendation to the state parties to rectify this structure. But also, this is the point I'd like to emphasize, the fact that committee find a violation, meaning that the committee found that the domestic remedies mechanism didn't work well to provide the remedies. So my point is that we should rectify this situation, because otherwise all the children always have to go through the domestic remedies, and only after failing to get the remedies and then come to the committee. So my view is that not only about the substantive remedies, general remedies, but also the committee should pay more attention to the failure of this state party to provide effective remedy mechanisms to the children at the national level. And this is also related to what Tom and Nicolás touched upon, reporting procedures. The committee should promote OPIC, third optional protocol, more vigorously. And unfortunately, Japan, my country, is not a state party to the third optional protocol yet. So I have to work very hard. But at this moment, 48 state parties ratified the third optional protocol. The convention, main convention, has 196 state parties. So I believe that the committee should integrate access to justice issues more vigorously into the reporting procedures, because otherwise the rest of the state parties do not have the opportunity to be reviewed by the committee about the effectiveness of the domestic remedies. So this is my belief. And finally, I have, according to my watch, I have 4 minutes left. So I'd like to make some provoking observations. As I said, that the committee is not the court. The committee has various mandates. The main mandate is the country's review, and we do 196 countries review. Then now the case number of the case of the individual communications is increasing more and more. The committee is composed of 18 members, and we meet in Geneva 3 times a year, total of 12 weeks. We are supported financially and financial and human resources, which would support us, comes from the UN Secretariat, Office of the High Commissioner for Human Rights. Where is the court other than, again, I would say we are not a court, but think about the situation. Which court at the national level or regional level receive the reports and review the reports at the same time, receive the complaints from individuals and review and make decisions? Our capacity is limited, and resources available for our work is limited. So actually, I see some tension when we become more and more preoccupied with the individual communications, which doesn't mean that we have more resources or we have longer weeks to meet in Geneva. So though it's good, the number of the individual communication cases increasing, it means that the optional protocol is actually used more and more. This is welcome, and also we should promote more ratification, and we should promote the OPIC among the children in the state parties to the optional protocol. But at the same time, I think, again, we need to strengthen our other procedures, such as reporting procedures, to address the access to justice at the national level, the substantive issues, but also the procedural aspects. Tom shared with us what kind of obstacles the children have to have access to justice at the national level. Children, in the first place, of course, we should try our best to avoid the violations, occurrence of the violation. But when it happens, the children should be given the remedies at the national level, not necessarily always by the judicial proceedings, in many other ways, child-friendly ways. Mediations or by the national human rights institutions, we really need to look up beyond just the judicial system. So I think we all often talk about the child-friendly justice, but if that means that the courts become more friendly, or it is more accessible to the children. I think it's still narrow, discussion. We have to think much bigger about the child access to justice. So thank you very much. I stop here.
Thank you very much, Mikiko, for such an interesting presentation. It positively strikes my attention how you were able to build your argument on behalf of a more structured concern of access to justice throughout the internal systems in such a way that the committee's intervention in such a specific dimension, such as a reporting procedure, can be efficient and productive enough within the current framework in which it currently lies. Because as you just said, and Latin Americans know that, we can have a significant constitutional structure. Latin American constitutions are, most of them, fantastic. I'm from Chile, although I have Mexicanized now a little bit. We hope Chile is the constitution that more formally protects the rights of children. Reforms can be made, but if at local level, at the ground level, we lack of resources, willingness, and also those who may provide legal assistance, representation, or to be there for those resources, then of course we will end up having thousands of cases at the Committee of the Rights of the Child, as well as a circle between partially made decisions and other decisions that can be used as standardized reference by lack of effectiveness. I believe it is a huge challenge, and what you just said is extremely interesting on how to think about the protocol implementation at the same time that all of us together think about the periodic reports, the legislative reforms, public policy, the candidates we vote for Congress or to run for president. How can those agendas include the primary guarantees as well as the secondary guarantees of rehabilitation, indemnity, or remedies may become effective. Thank you very much for your presentation. And on top of that, you have a very soothing way of saying, but after that, whatever you say is pretty demanding, Mikiko. So I think it was very efficacious as well. This is just my personal opinion. We have received a few comments and questions, and perhaps we won't have much time for all of them. Nonetheless, I do want to ask a couple of questions to both of you. Ton, this is a specific question. All the challenges that you have identified regarding barriers to access, as well as the challenges of access to justice, have been potentially confronted with the challenge of what it means to add up to those issues, to add up the COVID-19 pandemic with the impact throughout the pandemic peak. In certain countries, the effects are still very significant, not in other countries where the conditions are different, creating impact now and into the future. So my question for you, Ton, is what has been the COVID-19 impact on other structural crisis situations regarding the access to a friendly justice system for children?
Thank you very much, Nico, for the question, and thank you, Mikiko, for the very interesting presentation. I think I didn't mention it explicitly, but we see the impact of COVID-19 on the justice systems across the globe. There are now more and more reports coming out showing also impact. maybe a rough summary is that the impact on the justice system is significant. The real impact also depends a bit on what was already in place before the pandemic, and systems that had some, had some child-friendly justice mechanisms in place. They were more capable of reducing the impact of COVID-19. They were more responsive and capable of responding to the first challenges, including, for example, shifting from physical hearings to more digital hearings. But systems that have not such systems in place, they were even pushed further away. There was one of the conclusions that, for example, also UNICEF drew earlier this year on the basis of a report on access to justice for children in COVID times. In addition to that, I think some of the barriers standing in the way of children accessing justice, including, for example, resources, it's likely that these challenges will also be affected by COVID-19 in the negative sense, and that it becomes even more challenging to get access to services because of the economic impact of COVID-19 that is now about to become more visible, and because of the impact of children on certain groups of children more significantly than other children, because of the fact that schools were closed, because of the fact that girls were pushed out of societies into marriages. All kinds of things happened because of COVID-19. So you could say a lot of progress made also was pushed back. And that has also impact on access to justice. But honestly, we are just starting to see the beginning of the real impact, I think, of COVID-19. And of course, as you mentioned already, COVID-19 is still happening and it's still there, So I think it is really something to keep an eye on, and calls for also an access to justice lens on that impact. That would be my reply to this important question.
Thank you, Ton. Yes, it has been a huge challenge, and it will potentially change our working agendas for the next decade. And it leads me to think about how we see normality as an exception. I come, and Mikiko also comes from earthquake countries that have earthquakes and tsunamis. However, traditionally, most of our countries historically thought about that as an exception. Every once in a while, there's a tsunami. Every once in a while, there's an earthquake. So crises are always exceptional, and they are not integrated to the long-term version of public policy, the economy, or right. And I believe that this is an opportunity. We cannot say, okay, let's sort COVID out until we wait out for the next climate crisis or the next crisis. How can we add that to this is a super complex challenge. Thank you very much, Ton. Mikiko, you pointed out two very interesting things. You said that at the end of the day, access to justice is realization, or being able to execute certain rights or justiciability whenever it's in our hands. And judges and lawyers play a major role. And at the end of your presentation, you mentioned that it is essential not to see access to justice only as a matter of lawyers or that resorting to the lawyers or to the tribunals or the courts, but it is something that encompasses a broader vision of access to justice. And I wanted to ask you specifically, what is the role role do you think other services play? Those those services that are not formally under the legal umbrella. We could think about human rights organizations or ombudspersons who are not justice per se, but we know that they're there. We understand them. But if you try to shift away and you try to see social protection systems, schools, hospitals, you get lost a bit. As an attorney, I get lost. I have a hard time to see it differently. And I wanted to ask you what your opinion is on how to integrate that view into the practice so we can broaden our concept of friendly justice beyond the strict sense of the justice system.
Thank you very much, Nicolás. This is a big question, actually, and I have been thinking over and over, and I am continuing to think. I agree that the judiciary, the court, is a sort of core or main, and but it might sound a little bit strange because I myself am a lawyer, and so I have law background, and I am a law person. However, sometimes I feel that a too much legalistic approach fails. For example, I have been struggling in the Japanese court because the Japanese court judges hesitate to apply international human rights treaties. So if we want to win the case in the court, it's very challenging. Of course, we haven't given up. But it's interesting when we file a case in the court and lose the case because of the lack of understanding of international human rights treaties or hesitance by the judges to apply. But this is part of the movement sometimes, and the working with the civil society, and because of such a movement using the court, the case will not be successful in the court, but it will create momentum, and sometimes the result comes outside the court, for example. This is one of the examples. The administrative remedies mechanism or the mediation, for example, also, in my view, the access to justice, part of the access to justice. And I am a lawyer, but very often, I just want to share some of my stories as a lawyer. When I have been, I have been practicing law more than 30 years. And through my practice, I learned from my clients many things. The clients sometimes want to get the money as a compensation. Sometimes they want the punishment of the perpetrators. They sometimes want to be heard, or sometimes, they want somebody like authority. Sometimes it can be the court or some authority to recognize what have happened. So it depends on what the people want to get in response to the injustice which occurred to the persons. So when we talk about the justice, very often we use the justice and the court interchangeably or almost the same things. But in my view, the justice is much broader. And when you look at, for example, the preamble of the UN Charter, which uses the word justice in a much broader sense, and for me, the justice is something which rectified injustice, including human rights violation. So, for example, these days, the committee just made a decision on the climate change case filed by the children. So those children are calling for the climate justice and, for example, environmental justice, which, of course, there are many strategic litigation for the climate change situations, but of those are all same children or go to the 26 or talk to the political leaders. So the justice is used, in my view, in a much broader sense. So this is my answer. And just to respond to the COVID and earthquake, I wanted to add one more sentence. Yes, in Japan, we have gone through the tsunami and earthquakes. And so we learned in that case, we have to act quickly. Of course, the court, of course, but also the lawyers, bar associations. So we have sort of developed a certain emergency action plan by the local bar association because the earthquake, the houses, the people lost house and lost the ID documents, and so the lawyers can be, can get together and provide the free legal assistance immediately. So that experience is shared by the local bar association within Japan, and also shared with the bar association or lawyers in other countries. For example, Indonesia and in other Asian countries, there are many natural disasters, including earthquake. So this shows the preparedness is necessary not only for the courts, but also all the actors who are part of the justice system, including lawyers and the bar association.
Thank you so much for your answer. Many questions. And also from Ton's presentation. Well, now we have to begin ending. We have been very punctual. I'm sorry. We didn't leave you much time at the start, but we wanted everybody to know who's behind these efforts, the University of Leiden concerning the rights of children. I have copied on the Zoom chat the link to the Observatory of Leiden's Children's Observatory. You can check it out and to review critically the steps of the committee. And as Ana Maria Ibarra and Tom Leafford said, hopefully in the next few weeks, that observatory will be in Spanish in a collaboration with the Constitutional Studies Center. And we wish for this critical revision to be read, of course, in Spanish as well. And therefore, to be able to give access to these debates and provide comments, thanks to the observatory. Okay, before giving you, our dear guests, I wish to invite you to the next session of this series, which will take place on December the 2nd, at the same time, in the same format. Well, we shall be addressing specifically the challenges in terms of admissibility, the denouncement mechanism before the committee with two big scholars, Ursula Kinkelly from the Corte University of Ireland, and I think he said Dab Dirk from the Leiden University as well. So with no further ado, I wish to thank you so much, Mikiko Otani, the president of the Children's Committee. She's been accompanying us with us. Professor Tom Leafford from the Leiden University. We organized this with him, and the executive director of the Constitutional Studies Center, Ana Maria Ibarra. Thank you for your support and for developing this project. So thank you so much. We'll see you back here on December the 2nd. Good evening, good afternoon, good morning.